Court SHOCKS left with Unanimous Discrimination ruling by Robert Gouveia Esq. Don't forget to like, comment, and subscribe, and let's go. I don't know what this Esq stands for.
Her name is Marlene Ames. The agency hired the petitioner. Her name is Marlene Ames. We saw she's white, confirmed. She's also heterosexual. Oh my gosh. Now the agency then hired a gay man.
Oh God.
To replace
so
a straight
surprised.
white woman. The 10th Circuit, for example, assumed that the rule applies to white plaintiffs on the ground that white individuals are members of a historically favored group. Yeah, you got too much privilege. Get out of here. A white woman won. And she's straight too. This came out of the Supreme Court of the United States, which is why I know you're shocked. What did you just say? A white woman won in the Supreme Court who's straight? Yeah, it's true. She came out after suing the Ohio Department of Youth Services. Her name is Marlene A. Ames, and we have a photograph of her in some location, which...
What is a Department of Youth Services? I really have no idea. We don't have something like that here, or maybe we have something similar? Let me know in the comments, what is this? It's from government? Yeah, it looks like. Let me know for why, what does this stand for? Why do you guys need this institution? I don't know.
She, of course, is the woman who sued Ohio Department of Youth Services. And the background on this case is wild because she was essentially demoted. She was not promoted, even though she was highly qualified. She is a white woman, okay? Just to be clear. We got photographic evidence here now, which is why we had to pause. Marlene Ames is in her lawyer's office back in Akron, Ohio. She claims she was passed over for jobs because this is who she is. That's discrimination. So the Supreme Court came back down, and this came out from Justice Jackson. She says, wow, we all are unanimous in this. They write, all right, Title VII prohibits employers from discriminating against employees on the basis of race, color, religion, sex, or national origin. And under our precedents, a plaintiff, someone like Marlene, may make a showing of disparate treatment, meaning she's been treated poorly, by showing the following: that she applied for an available position for which she was qualified, but she was rejected under circumstances which gave rise to an inference of unlawful discrimination. Okay, so that's the standard. I am working here. I'm qualified. I should have been the next in line for this position. I didn't get it. Someone else got it. And I think I have an idea why that other person got it. It's because of something discriminatory. Now, the question in this case, writes the Supreme Court, is whether to satisfy that burden, prima facie burden, which is like checking the boxes. Did you just check the boxes? If you check these boxes, then you're good. Now, does a white woman, is that standard applicable to a straight white woman, is what we're asking. A plaintiff, here's the question. Does a plaintiff, though, who is a member of a majority group, are they treated differently? Do they also have to show an additional checkbox? Okay, so like this is if you're a minority, you got to check those two. But if you're a white majority, you got to check all three. So the lower level judges inserted this one. They said, you also must show background circumstances to support the suspicion that the defendant, in this case, the white woman, is that unusual employer, that it is unusual employer who discriminates against the majority. Now, we hold that this additional background circumstances, so does the white person have to prove additional facts to support the suspicion that the company is that unusual employer who discriminates against the majority, which is a weird phrasing. Like, what kind of a sentence is that? That the employer is the unusual employer who discriminates against the majority.
Yeah,
like, so
it's kind of difficult for me to understand this, but I think I got it.
And so you have to overcome the presumption. So it's very hard for you to do that. It's like, well, most employers don't discriminate. You're white. Since most employers don't discriminate, you have to overcome the fact that they don't discriminate. So that's like a serious hurdle. Now, they say, no. Where'd that come from? We hold that that requirement is not consistent with the law or our case law, just made up by some judge that construes the statute. And so accordingly, we vacate that judgment and we remand, and this case must go back, and you just got to apply those two factors. You can't just say all white people also have to fill this one out because they're white. Now, the Ohio Ohio Department of Youth Services, some background on this and how this whole thing went down and works. They operate the juvenile correctional system. Now in 2004, the agency hired the petitioner. Her name is Marlene Ames. We saw she's white, confirmed. She's also heterosexual. Oh my gosh. To serve as an executive secretary. Now Ames, that was in 2004. Lots changed since then, all right? Now Ames was eventually promoted to the program administrator, and in 2019, she applied for the newly created management position in the agency's Office of Quality and Improvement. Now, although the agency interviewed her for the position, it ultimately hired a different candidate. Oh no. A lesbian woman to fill the role. She's like, I've been here since 2004. You hired Korean all of a sudden? Now, a few days after Ames interviewed for the management position, guess what happened? Her supervisors also removed her from her role as the program administrator. She also got demoted. She accepted a demotion to the secretarial role that she had held when she first joined the agency, and that resulted in a significant pay cut. Now, the agency then hired a gay man. Oh, to replace a straight
oh my
white
God,
woman. Yeah.
not
Diversity,
again.
You know, like
no,
the whole agency is
no.
gonna perform so much better now because they got a lesbian and a gay man up here. Everything's gonna be perfect now. No one's gonna be late to work anymore. No one's gonna leave food in the microwave. Everyone's gonna clean out their garbage at the end of the day. Wow, progress. Now, Ames subsequently filed this lawsuit against the agency under Title VII. They said, what? This is ridiculous. I was entitled to this management promotion and I got demoted instead because I'm a straight white woman. Now, the district court granted summary judgment to the agency. They said, oh gosh, you're complaining about this and you're a white person, get out. So they found against her. The court analyzed Ames's claim under another case in 1973, and that establishes a framework, right? That gives us some checkboxes to evaluate. What is disparate treatment? How does it work? What is circumstantial evidence? What is good enough to prove that the gay man was better qualified or not better qualified than you? Now, at the first step of that framework, the plaintiff must make a prima facie showing that the defendant acted with a discriminatory motive. Okay, so checkbox 1, discriminatory motive is what we've got. So we're asking ourselves, do you check those boxes? Now, relying on the circuit precedent, the district court concluded that Ames had failed to make that showing. She had not suggested evidence of background circumstances, suggesting that the agency was the...
I'm sorry if I'm not saying too much. It's because I don't understand U.S. laws. I don't even understand. I don't even know which institute is that in your country. I will have some search later, but I would like if you guys can explain me in some easier way in the comments, like always you guys do to me in these circumstances. And also paying attention because he's saying like a lot of fast stuff, so that's why I mostly silence it. Because it's really hard to... I don't know. I don't think I can add too much about this, but I'm understand pretty much everything up until now, and the thing doesn't seem to look good. Oh my God, that's so
who
terrible.
Discriminates against members of a majority group. He's like, most employers discriminate against minority groups, so it must be rare. If you're a majority, then the likelihood of your claim being true is less, because he calls it rare. Now, without that evidence, the court held, plaintiffs who are members of a majority, white, including heterosexuals like Ames, could not discharge their evidentiary burden at the first step of the McDonnell-Douglas inquiry. Now, the Sixth Circuit affirmed this. They didn't care either. And a lot of this is actually being around her heterosexuality. We're not seeing much race in here, but she just happens to be white as well. Now, the Sixth Circuit affirmed, like the lower level court, they said, well, she's white. I mean, if she was a woman and black, this would be a different conversation, right? So the whiteness matters. They're not saying it, but it definitely matters. If she was a woman in any other color, then she would have not been in the majority. So they don't want to say white here, but that's what they're talking about. Because if they said white, that's going to be like really bad. They're like, well, it's not a majority. That means white. Now, like the district court, the Sixth Circuit held that Ames had failed to meet her burden because she had not shown any background circumstances to support the suspicion that the defendant is the unusual employer who discriminates against you. It's like, well, that would never happen. So you have to really convince us that it did. Now, the court reasoned that Ames, as a straight woman, was required to make this showing in addition to the usual ones for a regular case, right? So she gets an extra checkbox because of her white privilege. Yeah. Here, you have some extra things you have to do in order for your claim to be valid. Enjoy it. Now, and it explained
The privilege
that plaintiffs can
of not
typically satisfy this
only
burden where applicable
not
by
even
presenting
not even
evidence
say
that a member of the
privilege, not
relevant
even that.
minority group, here gay people, made the employment decision at issue or with statistical evidence showing a pattern of discrimination. All right, so you got to show us that the gays have taken over against you. The gays have taken over against the straights. Now, the panel concluded that the agency was entitled to summary judgment, gays win, because Ames had failed to present either type of evidence. Maybe you just are terrible at your job. Gays are much more whatever. So Judge Kethledge concurred in the court's decision and wrote separately to express his disagreement with the background circumstances rule. So what? Where the hell did that come from? In his view, the requirement was not only unworkable in that it required an assessment of evidence presented by different plaintiffs under different standards, but it's not even in the law. The Judge Kethledge's like, what? It diverges substantially from the text. It's not even in there. Can't just make this stuff up. Now, the Sixth Circuit decision reinforced a circuit split as to whether the majority group plaintiffs are subject to a different evidentiary burden than minority group plaintiffs at the first step. And so the Supreme Court says, we granted this case to hear about it. And here's more. They say the disparate treatment provision, SCOTUS writing, Kitanji, it stops employers from intentionally discriminating against their employees. There's a 3-step burden shifting framework for how this works. And burden shifting, we've talked a lot about lately. One side has to generate evidence to kind of push it over the line. And once that's done, then the other side can overcome that burden, or the burden shifts to them to rebut that and push it back over the line. So in McDonnell versus Douglas, we got a 3-step process for this. At the first step is familiar. The plaintiff, the white woman, has the initial burden of establishing a case by producing enough evidence to support discriminatory motive. If they clear that burden, then it shifts to the employer to articulate some other non-discriminatory reason for why that person was rejected. Now, finally then, right, so she says, oh, it looks discriminatory, kicks it to them. Oh, great, she met her.
It all makes sense. It's nice to see how things work clearly on the law there, because here it doesn't. It clearly doesn't here.
Then they say it's not
But yeah.
discriminatory. They kick it back. And finally, if the employer articulates a justification, then the plaintiff has a fair opportunity to show that that was a pretext. Okay, no, you were late a couple times. No, it's not because I was late, it's because I'm straight. Now, a plaintiff may succeed in this by directly
I love that phrase. It's not because I'm late, it's because I'm straight.
persuading
Oh my
the court
god,
that
that's so
a
cool.
discriminatory reason more likely than not motivated the decision. Now, for most plaintiffs, the first step of the framework is not onerous. It's pretty simple, unless you're white. A plaintiff may satisfy it by simply presenting evidence that she applied for an available position for which she was qualified but was rejected, which gives rise to an inference of unlawful discrimination. It's like super low standard. What kind of inference? What do you need to prove? What's the evidentiary standard there? But under Sixth Circuit precedent, plaintiffs who are members of a majority group bear an additional burden at step 1. They must also establish that background circumstances support the suspicion that the defendant is that unusual employer who discriminates against the majority, right? That's that extra checkbox. Now, as outlined below, the Sixth Circuit's background circumstances rule cannot be squared with the actual text in the law. It's pretty clear. It doesn't say that, so you can't say that it does. They go through, they give us some background on this, a lot of precedent talk here, and more case law stuff. They write, Ohio barely contests any of that at all. They know what the rules are. In fact, at oral argument, their state repeatedly acknowledged that this provision imposes the same burdens on a majority group as minorities. Now, its brief likewise offers no justification. Why would we have a heightened standard for white people? They can't answer it. Instead, the state came back. They tried to attack the premise of the question, presented by arguing that the background circumstances
Oh my
rule
god,
does not
oh
operate
my
to
god.
subject
Of
them
course,
to a
of
heightened
course.
standard at all. They
Of
say,
course.
so what if they have to do that? It's just another way of asking about the same thing that we're allowed to ask about. They say, no, it is not, Supreme Court writes. This contention is directly at odds with the Court of Appeals description of background circumstances. The Court of Appeals explicitly held that Ames is heterosexual, which means that she must make a showing in addition to the usual ones, right? So don't act like that's not how you were interpreting this. She was straight and white, so that is not qualifying for the minority benefits. So instead, it's in addition to. That's what the Court of Appeals said. And the ensuing
Oh
passage
my
of the court's opinion
god,
confirmed,
oh my
yeah,
god.
it is a higher evidentiary standard because she's straight. The court also stated whether Ames made the necessary showing of background circumstances is the principal issue here, because otherwise Ames' case was easy to make. The court then recounted. They said, well, she was qualified. She had been denied a promotion in favor of a gay candidate who was then later demoted in favor of another gay candidate. She got replaced by a gay and then actually went down lower. Evidence that would ordinarily satisfy this is right there. She got demoted and another gay man man got the job. Before it specifically faulted Ames, she says, well, you can't show that there's any background circumstances, like how that's abusive to you at all. They say ridiculous. In short, the Sixth Circuit expressly based its holding on the fact that she didn't meet the additional white checkbox. Ohio's attempt to...
And you know what's most terrifying? This is happening worldwide for a bunch of years already. And I've noticed that a long time ago. And I think a lot of people noticed that a long time ago. But even so, we could do nothing. Just look at and see it happening. But I'm pretty sure that there's a lot of people that are still sleeping about these circumstances. And the more you do this stuff, the more people like that you put inside, the more you change the way these companies work, the way that they act, the way that they think as a company, the things that they want. One thing leads to another, and everything, it's a chain of disgrace, really. It's a spiral of disgrace.
Misses the mark by a mile. Kitanji says this. Well, Ohio also urges this court to affirm the judgment. They say, well, we got alternative grounds. But those alternative grounds would not require us to resolve these issues that the Court of Appeals did not address. We granted review. We leave it to the courts below to figure out if this all still applies based on the other factors. But you can't add in that third one. Now, the Sixth Circuit has implemented a rule that requires certain plaintiffs, those who are members of majority groups, to satisfy a heightened standard. But we conclude that that law does not impose that heightened standard on white or straight people. Therefore, the judgment below is vacated and the case remanded for an application under the proper standard. So ordered by Kitanji, and we've got concurring opinions from Justice Clarence Thomas and Judge Gorsuch, both writing. Justice Thomas Clarence, who's coming up on a record, the longest sitting judge on the Supreme Court, he says, you know, I joined the court's opinion in full. Much more baritone than that. I write separately to highlight the problems that arise when judges create atextual legal rules and frameworks. Thomas says, judge-made doctrines have a tendency to distort the underlying law and text, impose unnecessary burdens on litigants, and cause confusion for the courts. And this rule, the background circumstances rule, correctly rejected by the court today, is one example of this phenomenon. And the decision below involves another example. In fact, the Sixth Circuit also analyzed the claim under a three-step framework, but that three-step framework lacks any basis in the law. So that framework is also bad. You guys just made that up too. Just like you made the final checkbox you said was bad, so are the first two, says Clarence. It's not in the law. He says, now in a case, we can't even interpret what these things say, because it is kind of a weird rule. It's like you prove it, then they prove it, and you can overcome the proving. Now in a case where the parties ask us to do so, I would be willing to consider whether this framework is workable or even useful. So Clarence is like, come on back on this, we'll get rid of the other checkboxes too. Now the Sixth Circuit's background rule is imposing a heightened standard on majority groups. White people have to prove more. Straight people have to prove more. The rule requires a majority group to prove, in addition to the other elements, background circumstances. Now, this additional requirement, writes Clarence, is a paradigmatic example of how judge-made doctrines can distort the law. Now, as the court opinion explains, there's no basis for that checkbox anywhere. It says there is any discrimination against any individual, and so that little rule plainly contravenes the law. It imposes a higher burden on some individuals based on the fact that they're white or straight. Now, this rule is a product of improper judicial making, and Clarence Thomas does not like when that happens. In support of this proposition, the court also made a mistake in relying on the framework in McDouglas. And the rule here, the court is even kind of admitting, like if you add checkboxes to things, that's a problem. So why do we add the other first two? Because courts lack an underlying legal authority on which to ground their analysis, says Clarence, there is no principled way to resolve these ambiguities. The background circumstances suffer from this flaw as well. Now, how a court defines the boundaries of a population can affect whether a particular person falls into a majority or a minority group, right? He who can draw the Venn diagram gets to separate the people. Women, for example, makes up the majority of the United States as a whole, but not in some states and not in some counties. So is a white woman in some counties maybe the minority in that county? I don't know. Similarly, women make up the majority of employees in certain industries like teaching, nursing, but the minority in other industries like construction. So do you want to do it by profession? Whatever's most convenient for them, obviously. So when you start defining majority and you say, well, you're white, okay? It's even more difficult in the context of race.
And of course, I've been taught, of course, I thought about all of this stuff that he say already, and I dialogue with people a lot about these circumstances already, about everything that's happening. But it seems like people are only paying attention to this stuff now. I don't know. And I don't know if you guys will be able to fix it. Here, it's like I always say, here we all give up. There is just no fixing. There's nothing that can fix here, okay? It's a lost case. But you guys see, really, the more I see every day, the more I'm starting to have, like, faith that you guys can really fix your country yet. There's some glimmer of hope in the end of this dark tunnel, you know? You guys still have some hope of fixing your country. Go for that. Fight for it because you guys still have chance to change things there. It may be an illusion. Maybe I'm wrong saying that, and things are already lost there too. Because truth is that people nowadays doesn't have that much power anymore. I think everyone noticed that. I don't think if we ever actually had it to begin with. But in fact, people seem to have even less power nowadays. And I think what it's bring people more, letting people more aware is the advent of the internet, of course. And you're being able to share your thoughts. And people are starting to pay even more attention now in things that are not going well in their country. But thing is that, and a lot of people have been saying this for quite a long time, for many years already. It's not something that is people started to talk about right now. But thing is that everyone was living in alternative reality. People were not paying attention at all in this stuff. They didn't care at all. Now I noticed that there is a switch that a lot more people are paying attention to this stuff now because it started to hurt on their pockets, you know? It started to hurt where they live in their daily lives. And that's why you start to notice things, because you start to question yourself, you start to look for answers, and they realize you're fucked, you're screwed. So yeah, that's when you decide to try to do something about it. But most of the times and that's the most hard thing, is to realize that you can't do barely anything about it. Nothing much, actually. The only thing you can actually do that is the most effective thing possible is to share with someone else, is to speak to someone else, is to explain all the things that you discover by yourself and try to bring someone else that it's still in the dark, to give them more awareness and make a chain of people doing that, and maybe dream to change the reality for better. But it's so fucking difficult. It's way more difficult than all of these corpos and government push it against us. People need actual real pressure, and it's not just pressure by itself, because actually in my country people actually pressured for a lot of changes many times on the streets, like thousands and thousands of people. Enough of that works. So there is nothing, just a matter of people actually wanting it, you know. There is a lot of stuff involved, But what I'm trying to say is, you guys need to gather the most people all of you can, and try to bring awareness to most people. And so maybe you guys, if you have some chance to try to get back to what you guys also had your country before, that you guys are so proud of, you know?
Because racial categories tend to be overbroad. Now, American families have also become increasingly multicultural, and attempts to divide us up into a handful of groups have become incoherent over time.
Multicultural!
But they will not stop that. That's their entire game, right? Everybody's like a trading card. They're trying to create a full house. They've got 3 gays, 2 blacks, and 5 trannies. Like, oh, great, we're got a winning hand here, and we're going to win elections over that.
Oh
like,
my God,
now,
oh my
and
God.
even if courts could identify all the relevant racial groups and their boundaries, courts would still struggle to determine which racial groups even make up a majority. Black black employees in Detroit, for example, make up a majority in their city, but not in Michigan or the United States at large. So what is a minority? What is a majority? Similar problems arise with religion. Now, as with sex and race, says Clarence Thomas, a particular religion could make up the majority or the minority, depending on how the population is defined. He gives us a footnote about Asians too. He says, the term Asian, for example, is also extremely broad, masks all the different countries of origin. It's very complicated. So when you're talking about background circumstances, and it now requires courts to decide whether someone's religion or whether their religion compares with everyone else, can religion count to make you a minority? Those tasks are formidable. Americans hold wide ranges of views, and Americans have different views on whether Catholics or Christians. What? We are. The judicial process is singularly ill-equipped to resolve these kinds of faith-based differences. Courts that have adopted the background circumstances rule have offered no guidance on how to decide whether a particular person is a member of the majority. Instead, judges have been left to their own devices to make this stuff up. Most courts here, says Clarence, have appeared to sidestep these difficulties. The 10th Circuit, for example, assumed that the rule applies to white plaintiffs on the ground that white individuals are members of a historically favored group. Yeah, you got
one of the hugest mistakes.
Similarly, the DC Circuit applied the rule to a white plaintiff while acknowledging, well, of course whites are in the minority in the District of Columbia. Said some judge. Of course. Now, in other words, courts with this rule have enshrined into anti-discrimination laws explicitly race-based preferences. White plaintiffs must prove the existence of background circumstances, while non-white plaintiffs need not do so. Shout out to Clarence Thomas, the only dude who will say white, all right, in any of this stuff. It's true. Now, such a rule is undoubtedly contrary to Title VII, likely violates the Constitution. There can be no such thing as a race problem. Thankfully, today's decision obviates the needs for courts to engage in the sordid business of divvying us up by race or any other protected trait. Like, exactly right. Trading cards.
But now I want to bring something for you guys to think about a little bit. Do you guys think that this is the first time that something like this happened? You guys really thought that? It probably happened a lot more before, but none of the cases were taken seriously because of the type of government that you guys had before. And the entire X system were different. And because of that, everything was put inside a shelf, and just thrown that and forgotten, something like that, and never taken seriously. But why now? Why now they are looking at this stuff different, and they are acting different? It's something that you guys should ask yourselves too. It's just because Trump is there? I don't think so. I am not sure. I'm not sure. I know nothing about stuff. But you guys should start asking yourselves this stuff, Why just now? Why only now this is happening? Why just now people are paying attention to this, courts are starting to notice this? Why now? Why not before? They never thought about any of this before? They never received any kind of case, of judicial case like this before? Never, huh? What do you think that happened? I just want to bring this to light and put in the air for you guys to think about.
You're gay, you're a T, you're an L, come over here. And they just want to collect everybody. Stop it. We're Americans. We have that in common. Stop it. Now, I simply observe that the background circumstances rule is emblematic of the serious challenges that can arise when judges invent atextual requirements. And for too long, that rule is putting a deep scratch across the surface, and I am pleased the court rejects that today. Now, this case involves a second judge-made rule, which is also applying that framework. Now, you assume, without deciding, the court is saying that we're going to continue this framework that I think is bad. And the appropriate case, we should consider whether we're going to nuke that case too, but not now. He goes through the frameworks. He said it was made up out of whole cloth. They just made it up. Its contours have no basis in the law, in any other source of law. Clarence says, as far as I can tell, this court never even attempted to justify it on textual grounds. They just made it up, which is ridiculous, right? Like, if the law says, here's how to resolve these conflicts, then great, follow the law. It says, oh, they prove first and they prove second, and here's a way to resolve it. That's not what it says. The courts just said, this is how we think it should solve. Now, the doctrine framework exemplifies how judge judge-made doctrines can have amorphous bounds, writes Clarence. This was originally designed for bench trials, but today it has gotten way broader, and so we should not be extending this framework to new concepts. In fact, we should be limiting it, and the next time a case comes up here, it should happen. And Thomas continues, lots of problems with this framework, man. He's not happy about it. It requires that a plaintiff do a bunch of things, but it's a problem, right? Another problem and another problem. He says courts have no occasion to distinguish between what's actually happening in the case, and this has befuddled everybody since the beginning, and so it's time to end. That those who have carefully grappled with this framework for decades, they've been trying to figure it out for generations now, as he just listed, and they still can't make sense of it. You know what that means? The framework is unworkable.
Oh
and it
my
needs to go.
God.
So this case
Oh
did
my
not present the
God.
question
Oh
of
my
whether
God.
we should nuke McDonnell Douglas, but in the meantime, litigants in lower courts are free to proceed without it. This court has never required anyone to use it since Clarence Thomas. So Clarence is saying, hey, you can also just get rid of it. And the district courts are well equipped to resolve summary judgment without it. You've got cover from Clarence Thomas and Judge Gorsuch now saying, yeah, you don't need to actually follow those rules. Atextual judge-created legal rules, writes Clarence, have a tendency to generate complexity, confusion, and erroneous results, and I am pleased the court today rejects the white checkbox for straight white women, saying you got to show you deserve it before there can be any recourse for you. So very nice decision from the Supreme Court of the United States. Major victory for the country. Weird how judges continually manufacture new requirements against litigants that they don't like. But it was a victory for this woman, and congratulations to Marlene Ames out of Akron, Ohio, for having success at the Supreme Court. Unanimous decision. Ketanji, Kagan, and Sotomayor.
Before we go any further, I want to take this brief moment here to thank all of you, my patrons, that support my work here on YouTube, and especially my Three-Tailed Fox tier members, Heath Rowell, Fenny Sylvy, and One Lonely Wolf, for the incredible support to my work. Thank you very, very much. You guys are amazing. Also, thanks to everyone who donated to me through Tron, and to all of my YouTube members, thank you very much. You can support this channel life and growth with just $5 a month and gain access to many perks. This is less than a burrito. Check out my Patreon, link is in the description below. Good job, Lemon. Good job. Nice work. Congratulations, yes. Thank everyone for watching. Don't forget to like, comment, subscribe. Check links below, Patreon, Discord server, and Tron. And I will see you all in the next one. Bye!